So here's the question I get a lot. So Alain, I got married and I had assets, I had property in my name before I got married. Can I just do a will or a trust, giving everything to my kids and not provide for my spouse? So the answer to that question is absolutely no, unless your spouse also waived his rights as to Florida law. People think that because they get married and all their assets are in their name, that the spouse has no rights. Technically, if you go to have a divorce, you may win as to the fact that the assets were non-marital property, meaning not assets within the marriage. Although a good divorce attorney might get a piece of that action because the increase in value, or if the spouse provided funds or provided improvements to the property, it might make it marital property. But that's a question for a divorce attorney. However, when you pass away, what actually applies is inheritance law. And inheritance law says that your spouse needs to receive at least 30% of your estate, even though you obtained the property prior to being married. So unless you get a waiver of his rights, meaning through a premarital agreement or a postnuptial agreement waiving his rights to the elective share, then your spouse is going to inherit property that otherwise you obtained prior to your marriage. My name is Alain Roman and I'm a estate planning and probate attorney out of Miami, Florida. Make sure to follow us and give us a like. Make sure to share us and follow me at Alain Roman Law.